In this video, I'm going to discuss both mistake of fact and mistake of law as defenses to criminal charges in Louisiana. Mistake of fact is a legal criminal defense under Louisiana Revised Statute 1416. It provides the defendant a defense if he can prove that he honestly made a mistake regarding his interpretation of a fact that was necessary to support an element of the offense. Unless there is a provision to the contrary in the definition of a crime, reasonable ignorance of fact or mistake of fact, which precludes the presence of any mental element required in that crime, is a defense to any prosecution for that crime. In a trial, a defendant must be found not guilty if the jury finds that the defendant was ignorant or made a mistake regarding a fact, or two, that his ignorance or mistake was reasonable and that his ignorance or mistake precluded the existence of the required mental intent. So for example, Dan owns and operates a small shop where he works on lawnmower tools, cars, and other machines. He is known as the guy that can fix anything. He often sells parts and other items that come through his shop. So let's assume John purchases a used four-wheeler from Dan for $1,000. Although it runs, it's several years old with cosmetic wear and damage. Dan actually stole the four-wheeler days prior from a nearby hunting camp. However, Dan does not reveal this information to John. In fact, John asked him if it was hot, and Dan replied it was not and that he owned it legally. So John takes possession of the four-wheeler. Later that week, he's out running the woods and is stopped by an officer who is aware that the four-wheeler was actually reported stolen. John's arrested and is charged with illegal possession of stolen things. Illegal possession of stolen things is the intentional possessing, procuring, receiving, or concealing of anything of value which has been the subject of any robbery or theft under circumstances which indicate that the offender knew or had good reason to believe that the thing was the subject of one of these offenses. So let's apply the criminal defense of mistake of fact here. John did intentionally possess the four-wheeler, but he did not know or have reason to know that it was stolen. The best facts for John's criminal defense attorney to prove at trial are that he paid a good amount for the used vehicle and that he inquired about its legality. It's up to the jury to determine if they believe John was reasonable and that he did not believe the four-wheeler was stolen. However, if a crime definition expressly precludes mistake of fact or ignorance of fact as a defense, then that definition overrides mistake of fact as a defense. The most common example under Louisiana criminal law is a criminal charge of carnal knowledge of a juvenile under Louisiana Revised Statute 1480 and 1481. The charges expressly state that lack of knowledge of the juvenile's age shall not be a defense. Ignorance of the criminal laws is not a defense to any criminal prosecution. However, pursuant to Revised Statute 1417, mistake of law which results in the lack of an intention that consequences which are criminal shall follow is a defense to a criminal prosecution under the following circumstances. 1. Where the offender reasonably relied on the act of the legislature in repealing an existing criminal provision or in otherwise purporting to make the offender's conduct lawful. Or 2, where the offender reasonably relied on a final judgment of a competent court of last resort that a provision making the conduct in question criminal was unconstitutional. It's a rare situation when a defendant does not have criminal intent because he relied on a current law or high court judgment. However, it can happen. For example, I've represented a client in this situation and we used mistake of law as a successful defense. This example is based on a real case, not just a hypothetical. My client was charged with failure to register as a sex offender. This is a felony charge in Louisiana. His initial conviction was for crimes against nature by solicitation under Revised Statute 1489.2, which initially required him to register. At some point, he stopped registering as a sex offender due to a belief that the law no longer required him to register. And since the law changed, there is one provision in that statute that requires registration. That includes if the crimes against nature involved a minor, and his conviction did not. This was a change to the statute, and we were able to show that he did not register because he was relying on the law. We got the case dismissed. Defending criminal cases successfully requires a lot of creativity. It requires the ability to know which facts and laws to focus on and how to apply them. Reduced charges and dismissals don't come easily, but I know how to get them. If you have a criminal charge, feel free to give me a call. I'd be happy to help.